Welcome, everybody. My name is Michelle Sonin. I am the head of Northeast Asia at the Singapore International Arbitration Center. I am delighted to welcome you to this YSIAC and KCAB Next virtual happy hour. I do hope that you've brought your favorite drink so we can partake in a little bit of networking and chit-chatting and socializing, and also important discussions about the future of technology in international arbitration. So as you may have seen from the flyer, this is going to be an interactive event. So we would ask all of you to turn your videos on and your microphones on so that you can participate in the discussions that we'll be having throughout the course of this session. We are, YSIAC and KCAB Next are very excited to be holding this event during the Seoul ADR Festival 2021. It's an annual event that the KCAB International puts on. It's usually in person, and unfortunately, circumstances prevented us from doing it in person this year, although I really would have loved to see all of you in person. But the benefit is that we can welcome all of our guests from all over the world through this virtual platform and talk about really the future of tech through a virtual platform, which does seem rather fitting for the topic. So I also, before we start, would like to thank our co-host KCAB Next. We have Lars here, one of our panelists, who is a member of the KCAB Next Steering Committee, and we hope that you enjoy the event that we've got in store for you today. So we hope that this will be an exciting and novel event where we talk about the future, what is the role of young practitioners in a much needed social setting. I think a lot of us are starved for that kind of interaction after nearly 2 years of COVID-19. So the way that today's session is going to run is that we're going to break everybody up into small groups using Zoom's breakout room function. We're going to break up into small groups, and then within your small group, you're going to discuss topics related to the broad theme of technology in international arbitration. Before we break out into the groups, I'm going to provide this discussion topic for that round. So for example, the first round will be on the use of technology in arbitrator appointments. I'll provide a little bit more information when we get there. The small groups are actually going to be randomly made using Zoom. They have this random shuffle function, so we are not at all involved in making the groups. And you will, once you get into your breakout room, you're going to stay there for 9 minutes to discuss the topic and network with your group mates. After 9 minutes, we will have everybody come back to this main room, and then I will provide the next topic, and then we'll all get shuffled again into another group. So we're going to do this for 4 rounds. I will present the topics in more detail as we go along, but to give you a bit of a preview, all the topics relate to the use of tech in, and then the first round will be in arbitrator appointments. Second round is in document management and document disclosure. The third would be the use of tech in virtual hearings, and the fourth would be the use of tech in enhancing sustainability. So after we do the small group discussions on those 4 topics, we're going to have a short panel discussion in which our panelists, whom I will introduce in just a second, will recap the insights and the perspectives shared by all of you during the group discussions. We have a really diverse group of panelists today from 4 countries. Joining us are Joanna Chu, and if I could get you guys to raise your hand, Joanna Chu, Senior Associate at Bradle Brothers in Singapore. We've got Justin E. At TSMP Law Corporation in Singapore. We've got Lars Market, Nishimura and Asahi in Japan, in Tokyo. We've got Won-Young Karen Yu, a member of the YSIAC committee and an attorney at Kim In-jong in Korea. And then we've got Yuxian Zhao, also a member of the YSIAC committee and an associate Han-Kun Law Offices in Shanghai. So our panelists will, of course, also be joining the group discussions, as will I. Okay, so with that explanation out of the way, if I could again ask all of you to turn on your videos and turn on your microphone so that you can participate in the discussions with us. Hey, welcome back, everybody. So I hope that was fun. I think, the first round took us a little time to get used to it, but I think that the next few rounds went really well. And I know I learned some really great things from all of you. So thank you so much for indulging us and participating in that. I hope you guys enjoyed it as well. So we're now going to move on to our panel discussion slash recap phase. And I'm going to ask my panelists to get spotlighted. I can't say come on stage. And we'll just talk about some of the things that you guys all shared during your group discussions, and sort of share ideas for what the future is going to look like with tech and arbitration. So I will start with the obvious place to start, which is round one. What did we talk about in round one, which was on the way tech would sort of change and shape the way that we select arbitrators. Lars, could you share your thoughts on this and sort of give us some of the fun ideas you heard from your small groups?
Sure, Michelle. I had a really interesting discussion because we got into the topic of using artificial intelligence to actually not only crawl arbitrator profiles as such, but also crawl everything arbitrators say on social media. And there are famous cases. We didn't discuss this for lack of time, but there are famous cases where certain arbitrators from Europe made disparaging comments about parties from Asia, and later the award got set aside for that when this was found. So actually, you can save a lot of time and money by having artificial intelligence not only check arbitrator kind of the normal basics, but actually everything they've ever said.
Yeah, that's very interesting. A little scary, but very interesting.
Indeed. We then moved on the discussion, and basically I recalled that might have a chilling effect on arbitrators, and nobody's ever going to say anything interesting anymore because everybody has to be afraid to get challenged for something. And I gave it as an example, reading articles written by arbitrators that I found always very boring because nobody really said anything about the law. They just recited cases and said like, oh, this is going to be very interesting to see how this is going to develop. Now I'm guilty of doing the same kind of articles, but I was always very disappointed as a student. But then we had, I think it was Huang who pointed out, people should actually not be so worried about this, because everything arbitrators say and do in a real life case is always connected to facts. So if an arbitrator says, well, sometimes it might be appropriate to bifurcate, I mean, that doesn't mean that an arbitrator in a particular case, knowing all the facts and legal arguments by both parties, would automatically always bifurcate. So I think that was a very interesting comment. So we were basically shifting a bit back and forth in our discussion about what is good and what is not so good. To maybe, however, address a little bit, there are now virtual profiles, basically. So we talked, you mentioned arbitrator intelligence. And I think people are expressly asked, I don't know whether it's on arbitrator intelligence or on GAR ART, which is kind of the Global Arbitration Review offering on arbitrator research tool. Somewhere I've seen that actually arbitrators are asked to indicate how they would approach certain issues, which of course is helpful to the parties in a way. But on the other hand, it can sometimes lead to misperceptions about arbitrators and how they would approach a certain issue. So it is helpful in one sense, dangerous in the other sense. So I think even with the new technology, the old arbitrator intelligence of meeting people at conferences, of having drinks with people, of talking to people about arbitration, I think that still is going to remain valuable, even if we're assisted by tech. So maybe I'll leave it at that. But
Great. I think those are, yeah, interesting insights there. Maybe along similar lines, and I don't think we have time to get into too much detail here, but would the AI look at pleadings made by that arbitrator in their work as counsel and then use that sort of against them? So I think, the possibilities are really endless, and you can sort of weigh the pros and cons for all of it, but all very interesting. We have maybe just a very brief comment. If Karen would you like to give, sorry, I'm jumbled here. Too much beer. Karen, do you want to comment on this very briefly? That's what I'm trying to say.
I feel the pressure, but it's okay because I had a lot of technical issues in the first round, so my discussion was very brief. I was popping around different rooms. But just to tag on to what Lars said, I think one of the points that we raised was the difficulties or challenges that may arise because of the biases that are inherent in the data that are collected for the different arbitrators. And so going further from that, there has to be some kind of transparency in place in order to make sure that the biases don't overwhelm or overpower the selection process of arbitrators. But with that caveat, I think we did agree that it would be helpful to have more databases, and it could assist the institutional appointments as well to have a more diverse pool out there, especially in different jurisdictions or the lesser known jurisdictions, or that we don't know which arbitrators, or we're less familiar with the arbitrators.
Yeah. Great. Thank you for those insights. I would love to talk about this more, but we have limited time, so we will move on. Okay. Takeaways from round two. Round two was on the use of technology in document production and document management. So I will turn to Yuxian. Can you share with us your thoughts and some of the thoughts from our attendees?
Yeah, thank you, Michelle. And for document disclosure, I will divide it to two aspects. One is internal, one is external. My experience is more about internal. So I've tried those e-discovery softwares to help review documents, but as many attendees also comments in our discussion, I think at the end of the day, we still need human beings to make judgment on which document is relevant, which is material, and it's very difficult for AI to actually help us to pick up the final documents in response to our needs or the other side's request. And so my major is logic actually in my bachelor degree, and I read articles in which logicians spend a lot of efforts discussing how to describe relevancy and materiality in logical languages. So it means that it will be very difficult for AIs or for algorithms to actually understand what it means by relevance or material. So yeah, and I don't think that AI read documents in this way. So I think at the end of the day, all they can do is to pick up a group of materials, and we still need a lot of people, interns and associates, to review documents day after day to figure it out. And for external aspects, so and a lot of attendees also comment that they don't think that the document disclosure technology can bridge the gap between the civil law words and common law words as to document production, because it's more about an embedded idea on who should provide the documents. And I'm from PRC, so we follow the civil law words more as opposed to common law one. And arbitrators believe that those who assert the claim should prove the claim itself and should produce the relevant documents, even though there are not many documents to do that. So it's not about burden, it's about who should provide the documents. So even though document disclosure technologies can help us to reduce the burden of picking documents, selecting documents, they haven't addressed the underlying the idea, the legal idea about evidence production. So yeah. And also, New Huang mentioned an interesting software called Exhibit Manager, used by many international firms. Yeah, as you said, it's very convenient to help prepare and organize exhibits and to put hyperlinks for cross-referencing purposes. And a lot of international firms are using it, but I haven't got a chance to try it. And I also haven't tried predictive coding, which sounds cool. Yeah, I think that's it. Yeah.
Great, thank you for that. So unfortunately, to the bane of associates everywhere, AI is not quite at the position to take over from document review. Joanna, do you have anything you would want to add to that?
I mean, I think we have machine learning. So it's sort of a program where basically you do a code and then the program itself learns as it goes through the many instances of whatever it's supposed to do. So in terms of helping parties to sift through documents, and find relevant and material documents, I think that is something that there's a potential for growth there. We may not be there yet, but it's something that, if we don't try, we won't know. So yeah. I think that is something that is probably somewhere down in the future may be more widely adopted. But like Yusen said, in terms of this deciding whether a document should be provided, I think parties would still want that to be done by a human person rather than an arbitrary program. Because when you have a dispute, you would want to submit before who's a person, you want to have your say, and that's going to be difficult if you have an AI in charge in that sense, because then it all boils down to written submissions. Not saying that written submissions are not good enough, but sometimes when the arbitrator may have questions that can help clarify certain matters, and I don't know how the AI would be able to do that. Yeah.
Yeah, I think definitely, we are seeing vast strides being made in the use of technology, especially in this area, so it's all very interesting. But then we're also seeing massive amounts of more documents, right, because of emails and e-discovery and so forth. So, jury's out on how things progress into the future. But I think it's a very interesting field to watch. Really an intersection.
I don't think the human element will be totally out of picture.
We're not out of a job yet.
Yes.
Never out of the picture.
Okay. Let's move on to the next round, which was on virtual hearings. And we'll have Justin start us off on this one. What have we learned? What are some tips that got shared? What are the challenges, so forth? Oh, and pause real quick. If anybody else has questions or comments, do feel free to do what Richard did and raise your little virtual hand.
Yeah, so I think the discussions that I've had in my rooms were really very interesting. And obviously, there's far too little time to be discussing everything, especially for virtual hearings, when I think everyone have their fair share of war stories and grievances to share. So one of the things I think that popped up was this. I think that technology is only as good as the willingness of its users to use them, as well as the technology themselves, and more importantly, the availability of the technology and infrastructure to the users. So one interesting point that we discussed with Rajdeep earlier on, who's based in New Delhi, India, is the absence sometimes of good, reliable infrastructure for the users in areas outside of the cities. And I think that this is probably reflective also of certain other countries, with less advancement in technology and infrastructure. So it's not just the availability of the technological equipment themselves, like laptops or smartphones, but really something that is beyond even the individual party's control, which is connectivity or broadband, things like that. Yeah. So this was something that was pretty apparent based on Rajdeep's experience, as well as some experiences shared with Indian lawyer counterparts that I discussed this issue with. So I think parity of technology and availability of it is pretty important moving forward if virtual hearings are here to stay to a large degree. And I think that the other point that I raised earlier is also the users, right? So I think many of you, this is YSIAC, right? So the youth, and I'm not sure about Lars though, but he's still on the edge of it. Sore point.
Sorry, Lars.
Yeah, well, he is starting to pivot towards the other side of the vintage. But we were saying that.
Still next.
Yeah, a lot of senior judges who are now arbitrators, as well as the more senior arbitrators, not all of them have readily accepted technology, and also not many of them might be willing to carry on with the use of virtual hearings, especially for the bigger hearings that involve cross-examination of witnesses and examination of evidence moving forward even after the reopening of borders. So that's, I guess, something that we would be looking at as borders start to reopen, right? I think that preliminary meetings, procedural hearings, and interlocutories, that could probably still be virtual hearing based, but perhaps many arbitrators would be more comfortable, as well as counsel would be more comfortable with physical hearings, especially when examination of evidence that witnesses are concerned. And I think from a personal perspective, being counsel also, I do find that physical interactions with the arbitrator are also very important for counsel to be persuasive. I mean, there's a reason why we would all rather be holding our drinks in our hand and meeting each other face to face rather than be doing this due to circumstances, of course. So I suppose there is a very important physical element in dealings between counsel in advocacy with the arbitrator, as well as in cross-examination, of course. But one interesting point, the final point I'm going to make is this: even though I think that cross-examination can be more effective in person physically, and this could, after all, just be illusory, right? Because what's the difference if you are really cross-examining somebody with a camera and you can see somebody? But what I find to be one plus point in doing it virtually is this, and it's the same with an arbitrator. I think that when we are looking up close at each other as we are now, we can actually see micro expressions in each other's faces where we're looking, certain twitches here and there, and I see Lars and everybody else shifting uncomfortably, which you probably wouldn't see in a physical hearing because everyone is of a certain distance from each other visually. So that's I guess one potential plus point to counter the negative non-hearing effects.
Okay, thanks, Justin. I appreciate that you tried to throw one positive in there. But no, I think those are really interesting points. And yeah, I think the issue of having a sort of uneven or inequitable sort of division of resources in terms of connectivity, and maybe one party's got the triple screens and the high tech microphones, whereas one party doesn't. And is that fair? And how does that affect the hearing? Those are all really interesting questions. Karen, anything you would add on virtual hearings? I know you just had one very recently. Anything you can, anything you want to vent?
No, not to vent, but I think from last year, now I think everybody's recognized that it's possible and it works, and you can actually have virtual hearings, especially even the longer ones. It's doable, but I think a lot of us still prefer the in-person, like Justin said, for various reasons. There is definitely an element of fatigue with having the virtual hearings. Like for some reason, it's a lot more tiring on screen watching, I guess, looking at the expressions and trying to catch what the arbitrator is saying throughout the whole hearing is different from sitting 2 meters away or 5 meters away, just kind of listening. I guess that's part of it. But also, that was one thing in terms of having it done. I think most people prefer in person, but also the point I wanted to raise was that in terms of cost, is it actually cheaper to have it virtual now? I mean, for counsel teams, you're still in the same place. You have all this technology set up. It's the only difference is that whether you're traveling to a different place a lot of times. So I think cost is something to think about, and whether virtual hearings are actually more cost efficient. It may not be in certain circumstances. I'll leave it just at that. I know we're running short on time again, Michelle.
Yeah, no worries. No, I think the cost, that's an interesting point, because we just kind of assume that it's cheaper, but the tech is expensive. And if you've got a hybrid situation where you've got one party in city A and one party in city B, you've got to rent two hearing facilities as opposed to just one. So yeah, I think that's an interesting comment, and one that maybe we don't always think about. Okay, in our last few minutes, let's move on to round 4. Which was climate change sustainability. Can tech make arbitration greener? And Joanna, maybe you could enlighten us on this one.
Yeah, I think we didn't have enough time to delve into it, but obviously we discussed the green protocols. Generally, the idea is reducing the impact on the environment. And I think for us to be able to achieve that, everyone has a part to play. So from the arbitrators, to parties themselves, to the arbitration institutions, and to even the law firms, right? So I know I asked last one question about whether he thinks it's incumbent on the arbitrator to push parties to agree on green protocols, because it is something that's fairly new, right? Not many people may be aware of what it is or what it entails. The simplest one would be traveling. Pre-COVID, I think people were more keen to meet in person, be at the same location for the hearings, be before the tribunal in person. But with the pandemic, that has caused us to have that mindset change. So now we are all obviously open to the idea of virtual hearings, because there's no way otherwise, right? And so of course the cut down on traveling would definitely reduce costs for everybody, as well as obviously the carbon footprints. But aside from traveling, there's all these other nitty-gritty. For example, if I don't remember wrongly, there's a commitment to reduce the number of printers in a level. I think try to have only one. Use environmental friendly ink, toner, and dispose of them in an environmentally friendly manner. Don't use plastic cutlery, don't use plastic cups.
Double-sided printing, small paper.
Yes. Use A5 size. If you have to print, then you use an A5 size printing. But as far as possible, parties should try not to, and agree on an electronic platform where documents can be exchanged, bundles can be sent, and everybody can receive it, so everything is consistent, right? So I think it also depends on the arbitrator. Some arbitrators, especially the older ones, may prefer to work with paper, right? The younger ones like Lars, happy to work with electronic versions. So I think Lars was saying that, for one of his arbitrations, he did ask parties to, if they had to print, to give him A5 size bundles, because obviously A5 is more portable, it's not as heavy. But in the end, he ended up looking at the electronic versions. So
Now it's on the spot.
No, I mean, it's all a trial and error process, right? Sometimes we don't know whether we want to look at the hard copies, and I mean, sometimes if the technology happens to be down, it's always good to have a hard copy on standby. I mean, with technology, it's all good and anything, but it's as good as your electricity is. If your electricity is down or your internet is crap, then if you don't have hard copies, then you are pretty much done for the day, because you cannot proceed, right?
Right.
So yeah, it's pretty interesting, and I think we can all help to do our part by promoting this and making it more well known to people who may not be aware of what this is, because it is fairly recent. I think the current form only came out early this year, if I'm not wrong. So, so I think more work can be done to sort of promote this, even for law firms. I think if I'm not wrong, I think it even went so far as to say, you should use energy saving lights and whatnot.
Yeah. I mean, I think a lot of it in the protocols would require the commitment of the firm or the hearing facility. But I think with, ESG becoming sort of like a very important thing to shareholders and stakeholders, that is something we may start to see. We've got a couple minutes left, so maybe we can let Lars answer for himself. Some of the things Joanna said that he said, but seriously, I know you sit as arbitrator quite often. And so I think that's an interesting perspective to bring here is, what could you do as an arbitrator and what are you willing to do to enhance sustainability?
Well, I'm personally, of course, I'm very willing, as you heard from Joanna. But indeed, I think, and that's the great thing, I think increasing diversity and also bringing in a younger pool of arbitrators is probably good for this goal of making arbitration more sustainable, because I think younger arbitrators are more prone to using technology and are less, I have to be careful, but I think there's only young people in the room, are less spoiled. So I don't think all of us would expect to only fly first class, even if it's only a 2-hour flight, and then to stay in the most expensive hotel in town. I think that's something that in a bit people have grown used to. But these are people that are in the business for a long time, and I think the younger people are just happy to be appointed as arbitrators, and so I think they really make an effort, and they're open to new technologies. I have to say, there is certain arbitrators that really put me to shame, because they say like, oh, you're still using A5 bundles, like how lame is that? I just have two iPads and I have everything on there, and I'll just mark up the documents as I go. And I was very impressed. So this is actually something I aspire to in the longer run. But I have to say, technologically I was too stupid to implement it yet. So I do this hybrid. But I think arbitrators can do a lot. And particularly something we also discussed with Joanna, in especially I think around Asia, parties are very afraid to step on the arbitrator's toes. There's a lot of deference. I have to say, coming from Europe, I saw a bit less of that, and people are a bit more cheeky when it comes to telling arbitrators what they like, and so it's on both sides, but also parties can actually say. So one trick we used as parties is to tell the arbitrator, actually, the parties are only going to be exchanging virtual electronic documents. But of course, if the arbitrator wants, we're going to print out everything for the arbitrator. And then we had a young arbitrator who said, no, I'm fine as well. So that's a way to handle it.
Great. Thank you so much, everyone. So this is all really interesting stuff, but unfortunately we are now out of time. So we're going to bring this to a close, but I want to thank all of our panelists for your really interesting insights and for helping to facilitate the discussion. And thank you so much to our attendees for participating in this. I hope that you found it fun. I personally am really glad that I got to meet some of you. I hope I get to see some of you in person sooner rather than later, and we can continue some of these discussions. Please do join us for future YSIAC and SIAC events. And thank you all very much. Have a great night. I hope to see you all in person again soon.